My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's live Facebook presentation, I would like to answer some inquiries I received regarding H1B visas and other non-immigrant working visas. What's going to happen with them, what Trump's administration has in mind for those working visas. As you're probably aware, about a month ago, Trump administration put a 60-day ban on immigrant visas, on most immigrant employment-related visas and some family-based visas, as well as devolutory visas, immigrant visas for people who are coming from overseas. Okay, so those people will not be able to enter the United States within the next now almost 30 days, a little bit longer than 30 days, unless that ban is going to be extended. And the question was, what's going to happen with working visas? And of course, in the United States immigration system, H1B visa is one of the most most commonly used visa for employment. Unlike many people believe, you can't just come and work in the United States. You have to have a special visa for that. And unfortunately, in the United States immigration system, those work visas are very limited. There are just really a few of them, and you have to meet that tight criteria. And as a rule, you either have to be very talented, like a person of exceptional ability or extraordinary ability. You have to have an employer who is going to be sponsoring you. Or like for H1B, you have to demonstrate that your employer, in addition to all other requirements, tested the market and basically could not find US workers, so people with employment authorization already in the United States, for you to be able to accept that visa and work on H1B visa. So when the president made his last proclamation concerning immigration about 30 days ago or so, he did mention that that proclamation currently at that time did not affect non-immigrant visas, non-immigrant work visas. But within 30 days, they were supposed to do the review of the situation and come up with a plan. So what that plan is going to be, what's going to happen with H1B visas? Will people who are waiting for the extensions, change of status, or immigrant or visas from overseas will be able to get those visas? What's going to happen? We have, as you know, also you may know that H1B visa is very often used by students who complete their studies in the United States in certain fields, especially like tech field. And H1B is an excellent opportunity for them to engage in work after they get those degrees and demonstrate their skills and talent. So right now, there is no specific proposal. They're still reviewing, so do not be fooled if you will see anything saying that this is what's going to happen. But right now, I can update you only based on rumors, basically, that are published by various reputable news sources that cite some people from administration about Trump's plans for H1Bs. And the biggest basically proposal, the scariest proposal that is out there is that Trump minimum wage for H1B visa holders may be $250,000. So what is going on, and how can it be happening? Why such a huge wage? Well, basically, when an employer would like to hire somebody in the United States, they have to pay not just the salary that they want, but the salary that is required by the government. And the level of that salary is regulated either by prevailing wage that is determined by the Department of Labor, or by law it has to be wage, that actual wage that an employee is paying for similar experience, similar conditions of employment to other employees. And the government, usually people say, place pretty high requirements for the wages. Basically, if you're trying to sponsor a foreign worker, you're already going to pay a little bit more than you would under fair market conditions, so-called, okay? So there are different levels of those wages depending on the experience that is required for the position. When a lawyer sends out the description of the position and requirements, we obtain the prevailing wage determination, and it is going to indicate the level of the wage, level 1, level 2, level 3. Those are the brackets for the wages that for this position can be paid depending on experience and requirements. So what happens is that Trump administration would like to propose that H1Bs will be available only to the highest paid level of workers, right? And that level currently, for the most common visas, most common positions that this H1B visas are being used, is in the range of $150,000 to $250,000. It means that if you are a small company that's trying to get somebody on H1B visa here, you will not be able to afford it. This is crazy expensive for you now, right? It means that you cannot hire an entry-level person, because who's going to be paying? It's either you would like to pay this crazy money to an entry-level person, right? Or you cannot hire an H1B worker anymore. That's basically what it comes down to. Also, of course, this high wages, you know, they're paid, according to the news articles, only to about 5% of all H1Bs applications. I mean, right now, there are, of course, H1Bs that do get that much money and much more. For example, Google is employing, according to some news sources, some workers on H1B visas, paying them over $1 million in wages, okay? And by the way, how I found out about that? From open sources. Those H1B petitions, for whatever reason, even with that high salary, were denied. That's why it became public information, because they said, well, you seem to advocate for high salaries, but look what you've done. You denied those very high salaried applications. So basically the plan is to cut off about 95% of H1B visas by keeping only the highest paid H1B visas, which for me, honestly, it doesn't make any sense. Because for those who would like to employ the foreign workers, they will still probably gonna go with them, and they will be forced to pay this high wage salaries instead of, you know, contributing them for other employees, potentially US workers. And for those employers who would like to take advantage of the young, talented people who happen to be on F visas here and would like to sponsor them on H1B visas, they will simply not be able to do that, because no startup, no small medium company can compete, in this market. If you have to pay an entry-level employee $150,000 in the field where usually you would pay $50,000 to $40,000, what's going to happen, right? So this is what they say is going to happen. We do not know yet what's actually going to happen. We do not know if the proposal like this will come about, going to affect people who already filed for it, or it's going to be a future proposal. If it's going to be something like affecting people who filed for change of status or extension of status. We know that there is a huge problem with H1B visas, especially going on right now as it is. It's because if H1B person was fired, they have only 60 days maximum to find a new employer. and if they don't find a new employer, they be out of status unless they will file for change of status. So the whole thing with work visas right now is a big mess, I would say. Also, what's not being discussed yet is that many H1Bs are being used in medical field, actually. And for those H1B visas, as a rule, you do not need to comply with the lottery, with cap, so-called cap requirements, right? They do not have to participate in lotteries, those cases. So what's going to happen with those cases? Will they require nurses to be paid $250,000 per year? Unclear. Really, I don't think that people who are working on these proposals really, have any good intentions and heart to help the employers and employees, apart from perhaps to somehow, try to say that if they impose this high salaries, all of a sudden the employers are going to hire only American workers. That's not going to happen, not how it works. For once, there is no enough workforce, people who in the United States will satisfy these requirements. Because if there were, H1Bs wouldn't exist at all, right? We wouldn't need these work visas for foreigners. So this is a situation that we have. I mean, it's not funny because we have a lot of people who are very talented, very well deserved. They studied, they have excellent degrees and excellent talents that we should be able to use, and we wouldn't be able to use because of this short-sighted proposals. I personally hope that such a proposal with this gigantic inflated salary requirement is not going to go through, because it doesn't make any sense for me. I also think that there are legal barriers to implement it, but we will see. So as of now, non-immigrant visas are not affected. I would recommend anybody who has a non-immigrant working visa to enter the United States as soon as possible, just in case, if they can. Because those 30 days are coming up, the 30 days within which the administration was supposed to have a new plan are going to happen in about a week or so. So in about a week, we're going to, maybe earlier, we're going to hear what is the actual proposal is going to be, and what's going to happen with those non-immigrant visas. And by the way, H1Bs is just one aspect of it. We also have O visa, P visa, E visa. When technically it's an investor's visa, but they may just bring it under it. Why not? Because spouses or dependents of E visas may have an open market work authorization, which they may be worrying about. Then we also have, of course, some other work visas that may be affected. Just in the end, I would like to say that those of you who have F visas, you may be aware, maybe your DSO shared this information, that if you're experiencing extreme hardship, you can file for extreme hardship related work authorization. All right, even though under normal circumstances, F visa holder will not qualify for the work permit. In circumstances where you experiencing unpredicted extreme hardship, you may have that open market work authorization. It's different from the work authorization you may receive when you work on campus. Okay, so that's something to know, and I think that's something, if you have the situation, you should absolutely file for, because who knows what's going to happen next week. All right, so I hope you enjoyed this presentation, and let me see if I have any questions to answer. I have my social in December, waiting on my green card. My daughter petitioned for me, waiting to petition my son, who is 16. Okay. My daughter petitioned for me, waiting to my son. So I understand that you would like to receive your green card first to petition your son. I guess that's the essence of the question. Well, the best advice I can give you is that you should follow up with USCIS right now. If your daughter was the one who petitioned for you and you don't need an interview to adjust your status, you may be able to, if there are no issues to adjust your status, you may be able to get the green card without the interview currently, okay? Because that's how it was all the time. Parents will most likely not need an interview until a couple years ago when they decided to call for the interview everybody. So I would, if I were you, I would follow up with USCIS, perhaps involve the congressional office just to make sure that your case is being decided expeditiously. Can we file I-130 petition now? Will it process? I'm ready to file, but need to know if things... Absolutely, you can file I-130. Petitions are being accepted. You know, it takes time to process them. It takes about 8 to 9 months, sometimes longer, depending on the category, who you're sponsoring, but absolutely they do accept them and they need your money. They just said they're gonna go broke soon, so I'm sure they will accept it. I have a pending asylum, so can I apply for adjustment of status? No. A person with a pending asylum application, based on that pending asylum, of course, cannot file for adjustment of status. You may file for adjustment of status if now you have a different ground for it. For example, a spousal petition by your spouse, who is usually a US citizen, and only if you are adjustable. Let's say that you entered the United States legally, you have been inspected or admitted or paroled, okay? Then yes, you can. So that's employment-based adjustment will likely not work, okay? Because you need to be in lawful non-immigrant status all this time for the employment-based adjustment to work, all right? So I guess the answer would be yes and no, depending on the circumstances. The USCIS asked for things together, and I sent it in from February and still nothing. I'll give them some time. They've been working very slowly. It's February, right? So it usually takes them 90 days. And if you're waiting for the interview of your case, that the one that needs to be called for the interview, you have to be patient because, of course, right now they're not calling anybody for the interview. So as long as you have proof that you sent it to them, you just have to wait for their determination as to what is it that they would like to do. All right. All right, guys. So I hope this little presentation was helpful. Okay, so basically we need to wait and see what's going to happen. There is a proposal to cut off all H1Bs that will, except for those that will be in the highest wage level. We're going to see what's going to happen, and we're going to see what's going to happen with other work visas. And thank you very much for watching. Please share, like, and I hope to see you soon.